Alright guys, the leader of the indigenous people of Biafra, IPOB Nnamdi Kanu, don carry im matter go appeal court to stop the judgment when the Federal High Court be don fix to happen on November 20, 2025. For the appeal document when BBC News Pidgin see, when the date na 10 November 2025, na Kanu himself sign am sake of say na him dey defend himself for the matter after he ask im former lawyers to withdraw. Justice Omotosho of the Federal High Court bin fix November 20 to deliver judgment for the terrorism trial when the Nigerian government same on top Nnamdi Kanu, but the IPOB leader maintain say the court no get jurisdiction to try am, and say the charges against am no dey based on any valid law for Nigeria. Inside the appeal document, Kanu say na 3 things e dey challenge. Kanu claim say despite the question of jurisdiction when e lay before the court, the trial judge refuse to rule on am. E also talk say the trial court no gree to alleviate the evidence of the prosecution witness, vice versa, the cross-examination questions to determine whether the evidence dey discredited under cross-examination. The IPOB leader say im bin don file a list of witnesses and im indicate say e dey ready to start im defence if the court go first determine the issue of jurisdiction when im raise, but the judge no gree lis ten. Instead, e rule say he don waive im defence. If dis application no dey granted, Kanu talk for the appeal court document. E say the defendant fit dey unlawfully convicted without the opportunity to know the validity of the court or the count. So the jurisdiction of the trial court and offering defence on the merits. So Kanu ask the appeal court to give order make the Federal High Court hold on with the judgment when he be wan deliver until the appeal don dey determined. If not, e go cause irreparable damage to me as the applicant Kanu talk. One of Nnamdi Kanu former lawyers tell BBC News Pidgin say the Court of Appeal never fix a date to hear the application. The counsel went plead anonymity because e no longer dey legally recognized as Kanu counsel. Explain say if the appeal court grant the application, e mean say the proposed judgment no go get heard. But if dem no grant am, the trial court go go ahead and deliver judgment. But as long as say motion don dey filed to stay proceedings for the trial court, the judgment no fit go through until dem hear the motion, e talk. However, another legal practitioner say the process when Kanu file for the appeal court no go affect the delivery of the judgment. This lawyer, when also asked to remain anonymous, say the Court of Appeal no fit grant a stay of proceedings because e no dey based on when specific pronouncement or ruling or judgment of the trial court. So about the no case submission when Kanu dey appeal, the lawyer say the time don pass to appeal am unless Kanu go ask for the leave of the court to appeal am. Remember say the ruling and the no case submission na on 26 September 2025. According to website of the Court of Appeal for Nigeria, e get 14 days to appeal an interlocutory decision and 90 days to appeal final decision. So the lawyer when follow the tori personal talk come explain say dis appeal wen Kanu file now na interlocutory appeal, therefore the time to file don pass since. Also, checks by BBC News Pidgin show say selection 306 of the Administration of Criminal Please, section I meant to say section 306 of the Administration of Criminal Justice Act ACJA 2015 tok say application for stay of proceedings in respect of a criminal matter before the court no go dey entertained. E dey understandable say Kanu go file dis kind appeal because e no be lawyer, but e show say the lawyers when dey advise am know wetin dem dey do, the legal practitioner tell the tori person. So my people, this is what happened today. Mazi Nnamdi Kanu want Justice Omotosho, to stop that judgment on the 20th of November. You understand? So, my people, now here we will drop this one. We will come back again as the matter the hot they come. Thank you. See you in my next video and bye for now.